That's interesting. I can't read that. And the many fine thoughts about me and my time with the board and the president. Keep in touch. That's from Stu. And then there's this little card says, "Oh, happy me." So, and then there's a note from Cindy to thank you for the spoonful of comfort and I greatly appreciate your thoughtfulness and consideration during this difficult time. Losing my mother has been very hard and your kindness provided comfort. Thank you for being there for me. And that's from Cindy. And I'd like to offer the same note of thanks, as there were lots of expressions of sympathy and comfort and for the soup and warm food and good thoughts were very helpful to me as well. So thank you for those.
Okay, so the notice of this meeting has been published on the board site and Secretary of State's website. It's been emailed to everybody in the state, all the necessary government officials. So now we'll move forward to a review of minutes from our last board meeting in December. You all have a draft of the meetings in front of you. So were there any additions or edits to those minutes that anyone would like to bring up?
I move we accept the minutes as is.
I second.
Having heard the motion to accept and second from the minutes of our December 9th meeting, is there any further discussion? If not, let's take a vote. All those in favor of adopting the minutes from December 9th, please let it be known by saying aye.
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 All those opposed? Hearing no opposition, the motion carries. Okay, the next item is moving into applications.
We don't have any applications for open session today.
Okay. So that brings us to the attorney's report.
Okay. So there are a few things to go over with y'all that are currently pending, as far as pending in the General Assembly and also executive orders. I will start with an update on executive orders. So if you click there in your agenda, you will see Executive Order 193. And if you open that, you'll see that Governor Cooper has signed this order, which deals primarily with COVID vaccines. And what 193 does is it provides that occupational licensing boards related to healthcare can waive rules and offer flexibility to allow licensees and others, you'll see what I mean by others here in a second, to provide shots, to provide vaccines. And Kathy and I had a long discussion on this when it came out, because the real question that occurred to us immediately was whether or not it was included in our scope of practice to provide vaccines to begin with. And you know, there's a lot of parallels with the with dry needling and other things that PT students are taught in school and use in practice. But it's not something we didn't think that PTs did on a everyday regular basis. It is something that with just slight or a little bit of training that it would not be an issue in our opinion, but it didn't necessarily immediately fall within the scope of practice for physical therapy. And so what the governor did was in section 3A, regulatory flexibility to expand the healthcare workforce. He says, or he lists groups of people who are under this executive order, which expires in May. He lists groups of people that healthcare boards can authorize to give these vaccinations. And let's see, there's 1, 2, 3, 4, 5 of them. The first ones are licensees of licensed occupational licensing boards licensed in other states. The second one are retirees or licensees who have inactive licenses. The third is skilled but unlicensed volunteers. The fourth is students. And then the fifth, he actually specifically names dentists. So of those categories, we discussed what may or may not apply to us. And Kathy, please chime in anytime if you want to talk about our rationale here, but kind of where we ended up with this, and we want to just have some discussion with the board on is since it's not providing vaccinations is not expressly provided in the scope of practice. If PTs want to do this, our suggestion as the board would probably be that it would not be, it's not called PT, wouldn't fall directly under our supervision, but it would not be prohibited, particularly if some training has been provided.
Yeah, I can chime into this. Where you're also going to see this in the agenda is in section 6. And if you close out of the governor's order and go down to the executive director's update where it says considerations for regulatory flexibility, EO 193, that document there is meant to be sort of the summary of information that I had when I wrote it. It's funny how things kind of keep evolving. I think there's momentum that's occurred, related to vaccinations in North Carolina. So it's kind of evolving over time. But what is not evolving is the fact that, performing vaccinations is not taught in the entry-level curriculum. So, I'm imagining is a given for everybody. And so, as David said, it's not considered within the scope, but if a licensee obtains the training and is competent to do so, and what I think we need to add in any other public statement is that they follow all other applicable laws. Vaccinations and that kind of thing tends to fall underneath the medical board and their practice act. So I think just stating following all other applicable laws, because a PT could work under the supervision of a physician, that physician could provide that training for them and deem them competent to do it, and they could work under that supervision as well. I did learn, this has all evolved over the last, 6 weeks, that the AHEC has created a free vaccination training that's remote. Kind of interesting because actual performance of the vaccination, but do it that way. And that's evolved, in part by this executive order, in part because North Carolina AHEC knew it was coming, and that, they were hoping to be able to mobilize other people to perform vaccinations. So one of the things I will add is that in my initial discussion with Jill Forsna, she was a little bit more cautious, I guess is the right word, because it's not part of entry level. Is there potential liability for people who haven't had, the entry level education to perform vaccinations? And while I think there are a lot of people who have asked this question, and that's where David and I had to respond to it earlier on, people want to help, they want to be a part of it. But, she was also suggesting that, number one, at this point in time, because of the limited supply, they have enough vaccinators. It's just that there isn't enough vaccine. And so there are other ways you could be helpful as, a worker at a vaccination clinic. So, the way to get plugged in, there are multiple ways to get plugged in, not just to be able to provide vaccinations. It's kind of funny. So yesterday, the notification came out about that big vaccination clinic that's going to be at the Greensboro. I can't think of the place exactly right at the moment where it's going to be, but apparently the supply is going up now that the Johnson & Johnson has been approved, and so people still may want to make their choice. Do you want to help by vaccinating or doing something else? But I think in terms of summarizing what the board's response could be, David's already said it, that it's not in scope. Get your training and competence, and then comply with all applicable laws. I see Rosa. Rosa, did you want to say something?
Yes, I had already the experience helping in the mass vaccination. And I can tell you that you can help in many ways. For instance, since I'm bilingual, I was translating for people that didn't speak the language. And in that time was like 600 volunteers from the hospital, between nurses and PTs and anybody that could assist. And only 6 tables were vaccinating. But the rest of the people is the need to be kind of babysitting or sitting people that just have the vaccine and they have to wait. Some people has to wait 15 minutes. Some other people have to wait 30 minutes, depending on their condition. And I think a PT will be really awesome in other spaces without having to handle needles. It's really a big need because it's a whole day. So you have the need to have shifts of people, but I think you can help without the need of handling needles.
Yeah. Well, thank you all for those comments. And Kathy and David, thank you for working so hard and processing and thinking through this whole question. I want to bring our discussion back to the attorney's report. So David Gadd, I'm going to turn it back over to you.
Okay, so the next item there is a legislative update, and there are 2 matters if you click in that section. The first one is an audiology bill. As we know from the lawsuit with the dry needling issue, there's lots of overlaps of scopes of practice between occupational licensing boards in North Carolina, and this is one we're kind of keeping an eye on. The General Assembly has filed this bill which updates some of the statutes related to audiology, and buried within that is some definitions and some descriptions of their scope of practice as it relates to vestibular systems and disorders. And that PTs have training in that, and that's one of those overlaps, as well as with other, the medical board obviously would be an overlap on this as well. So they're looking at, I'm not exactly sure what prompted this rewrite or this bill to be filed, but they're looking at just updating some of the language in there, which also updates the descriptions of the scope of practice and has some overlapping issues there.
I have a question about, whoops, excuse me.
Go ahead, Jamie.
Well, I read that and I don't know what they had prior, but I did not think audiologists did treatment, that they mainly did testing, and in their new scope, they now treat vestibular disorders, not just BPPV, but they had habituation and adaptation exercises, which kind of surprised me because we've had a lot of training in that. I don't know how much training they get. And that was a little bit of a concern. I've taught classes where audiologists have attended on vestibular to see what's done, but they don't usually perform that part of it.
Yeah, I think that was what I was going to say, is I think the audiologist wanted the legal authority to be able to do more treatment with vestibular disorders. So that's what prompted it. But because we also do it, who knows whether we'll be asked whether we have any opposition to that. Right now, I think there is some opposition from the medical society. But, it's not primarily our bill. It's just that because of the overlapping scope. We're bringing
So we don't really have an input, because I would be concerned that they don't have the training to do vestibular treatment. But I didn't know if we had any recourse.
Well, I think, with overlapping scope issues, as we have experienced through our own legal issues with that, is that it's up to the board of that particular profession to make the determination about whether they do have the appropriate training, education, competence to be able to do it. And I imagine that that's what will be discussed, if anything, at the legislature, and as they consider this. So I don't think, David, correct me if I'm wrong, but we wouldn't weigh in unless we were asked.
I think that's right. We can definitely keep tabs on it, and if an opportunity arises to insert, opinions, then we can do that, and as particularly as it pertains to what our scope of practice is. But I think what, given that last round of litigation we went through, I think that what the court's final answer was is it's up to the, as you said, Kathy, it's up to the Occupational Licensing Board to state what their scope is based on a bunch of different factors, and training, obviously, in this situation is the main one. If there's nothing else on that, the next matter I have is the SAVE bill. SAVE stands for Systematic Alien Verification for Entitlements. And this is a bill filed in the General Assembly to just require occupational licensing boards to run each applicant through the SAVE program, which is essentially a computer program run by the Department of Homeland Security, to ensure that each applicant, or as it's termed in the bill, each applicant for a benefit, which is what a license would be, is properly, their immigration status is up to date and been approved by the federal government. There have been various other attempts to require this kind of thing in the past. What I thought was interesting about this one is it has a section. It's when you open your attachment, it's at the bottom, called Private Enforcement. And it's basically says that anybody who lives within the state, if they believe a state occupational licensing board is not in compliance with the, checking the SAVE program, then they can sue in their local superior court and potentially get an order requiring the state agency to comply, and also impose civil penalties of up to $10,000 a day. So who knows if this will go anywhere, but it's out there, and we'll keep tabs on it. This would add an extra layer to our process, and I'm not sure, Kathy, I'm not sure if you're aware either of how difficult this would be to run through this program. I'm just not sure.
It would add to every single application, and I don't remember if it's in this bill, but the one that they posed last year was also, it had to be every licensee. So there was a retroactive review as well. That could have been another person we would need to hire to do that.
Right.
So because we don't participate in SAVE currently, I don't really know how easy or hard it is to use and how much time it adds to each individual application, but it's definitely going to be something.
Right.
Just like criminal background checks has definitely added time and processing.
Right.
So anyway,
there's also an additional report required, which comes along with everything, I think.
Right.
David, is this somewhat like E-Verify?
It is. It's similar to E-Verify. And honestly, having not seen the prompts that they give you in the program, I'm not sure exactly what the differences are. But that's what I was referring to when I said that there's been other things like this. That it reminds me very much of E-Verify.
Contracts, if not all, require vendors to do that already. So, I mean, it doesn't take a lot of time, but like Kathy said, that's another step to go through.
The next thing on the agenda here is just an update on the federal legislation. We talked about this at the December meeting. There was a federal bill filed back in October or maybe September, which provided liability protection for occupational licensing boards at a federal level. As you probably would imagine, the federal government, Congress, has been a little busy since October, and this has gone nowhere. It's still sitting in the same committee, and maybe we'll have some movement on this because I do think it's a good thing to have. But there's been nothing done since October, and we'll keep you updated on that for the next meeting. That's it as far as updates on legislative and executive matters. I am going to attempt to share a screen.
So what I've got to do, David, is make you the host for just a minute, and I got to find how I do that.
Okay.
Let's see now. No.
He should be able to share the screen without being host.
Oh, okay. All right, great.
Okay.
We'll let you go. While David's figuring that out, we've talked about board member training, and certainly David and I have talked about ways to kind of sneak that in throughout the year and throughout the different board meetings so that we can continue to help everybody be as well informed as possible in doing your job and fulfilling the responsibilities you have as a board member. So David wanted to present this one this morning, which I think is a good thing ahead of our closed session.
Right. So my screen says I am screen sharing, but can you see anything?
Yes.
Okay. I've got a PowerPoint up, and the first slide should say the disciplinary process. Is that what everybody sees? Okay.
Yes.
So what I thought I would do for those of you who have been on the investigative committee, this will be pretty redundant, but for those who haven't, I thought it might be helpful to understand what the process is. You as the board a lot of times are on the back end of all of this work that's gone into dealing with these complaints that have come in, because as either agreements are made with licensees or licensees request formal hearings, that's when the board is involved, and a lot of stuff has happened on the front end that I thought it might be helpful for you to understand. So this is my attempt to explain the process based purely on the Practice Act and the board rules and the steps that we go through to get kind of through these things, because they come in pretty regularly. The investigative committee maintains an agenda of 20 or so, I would say, is the average matters that we deal with on a basis of about every 6 weeks is what our meetings are. So the Practice Act describes in its powers and duties of the board section that the board can and shall conduct confidential investigations for the purpose of determining whether violations of the rules and the Practice Act have occurred. And there's about 5 steps in this process to kind of get through and resolve these complaints that have been lodged with the board. So step 1, a complaint comes in. The website has the form that we prefer to receive. However, that form isn't mandated by statute. We can accept complaints in any form as long as all of the requisite information is provided.
David, I need to interrupt you for just a minute. I'm sorry.
Sure.
I think our rules says that we can only accept them in writing, so I don't take them over the phone.
Okay, gotcha. So they only come in writing. I will say, and Kathy, I'm thinking of one in particular that we've received on the phone, and at that point you just request that they send everything in writing and use
Yes.
the form. Okay, so if you want to look at the form, it's pretty exhaustive as far as what they ask for, what we ask for, and it also has a medical records release right on there on the back page, so we can, through our investigative process, get documents and that sort of thing that we may need. A lot of them these days are by email. You know, hardly anybody uses regular mail to send these things in. They're virtually all sent to the board office by email. The second step would be, in this situation, Kathy is always the one that gathers these complaints from the information submitted, sends it out to the members of the investigative committee, which is one board member and Kathy, assisted by myself and the investigator, Mark Scott. And that's per the statute. So there's typically 4 of us in these meetings, and we kind of pour over all the information gathered on the front end during these meetings. And we also begin the process, step 3, of reviewing these complaints. So we get together, all the complaints are discussed in detail, what the facts allege, who are the parties, who we potentially need to interview and obtain records from. The board has the authority to issue subpoenas. So a lot of times those will go out to employers, hospitals, those sorts of things. It can be a struggle at times to get those in a timely manner because of all the issues regarding privacy. And typically the board will, at the kind of first step is the board will instruct the investigator on what needs to be, what additional information needs to be obtained. So that's step 3. Once we have all the information, and this can happen over a course of many months, or if the complaint is fairly simple, it can happen fairly fast. It depends on the complexity and all the allegations. But once we have all the information, the investigator has conducted the interviews, and records are retained as needed. Really, the standard that the investigative committee has to stick to as far as what to determine is whether there's probable cause to believe that a violation of the board rules or the Practice Act has occurred. And there's lots of definitions and opinions about what probable cause is. It's kind of a fuzzy term, but courts in North Carolina have defined it as a reasonable amount of suspicion supported by the circumstances sufficiently strong to justify a prudent and cautious person's belief that certain facts are probably true. So, it's really just what a reasonable person would think probably occurred based on the information that you've gathered. If if the committee believes that a violation has probably occurred, we then send a letter to the licensee and his or her attorney, if they have one, that invites them to the next investigative committee meeting. And since we've been doing this by Zoom, it's worked okay. I think one of the main benefits is to sit with these folks in person and kind of get their read on and their opinion on what actually happened. So that's a little more difficult for us right now during COVID, but we're still able to proceed with Zoom. It's just not ideal. The next step is to try to, we meet with them and try to come to some sort of settlement or agreement as to how to deal or resolve the complaint. What we typically do is we'll meet with the licensee and offer them our suggestion, the committee's suggestion on how to proceed. I'll go through in a minute what those options are. But once we offer them that suggestion, we don't make them tell us on the spot whether they want to accept our proposal, the committee's proposal. We typically say, we'd like to hear back from you within a certain number of days. And you also have to understand that our proposal has to be approved by the full board, which is what we're going to do some of this morning. Has to be approved by the full board before anything can be finalized. And then the licensee has an opportunity to come to the full board and say what they want to say. They can object, they can agree with the proposal, and you as the full board has an opportunity to ask questions and approve or reject the investigative committee's suggestion. If after we've gone through the process of collecting information, getting records, doing interviews, the committee believes that no probable cause exists, then at that time, complaints are dismissed, and we give notice to the complainant. And if the licensee knows about it, which sometimes they do and sometimes they don't, we'll give notification to the licensee that it's been dismissed at that point. The next step and the last step, if it's necessary, would be to provide the licensee with a formal hearing. And this step is only necessary if the licensee rejects the suggestion of the investigative committee, which happens on occasion. It's not too terribly common, but in this situation, the statute lays out very specific steps we have to provide as far as notice, giving them notice they can file a written response, and then requirements on conducting the hearing. And basically what this is doing is it's not only creating a record, but it's providing the licensee with all administrative remedies before any disciplinary action is taken to their license. The burden of proof for the board at this point is proving the facts by a preponderance of the evidence, which is a higher standard than just probable cause, what the investigative committee is required to determine. And the decision would have to be rendered within 60 days after it's made by the board. After that, if the licensee still doesn't like that outcome, they have a right to appeal to the Superior Court in the county in which they reside. There's certain requirements on how soon they have to file that petition. And then a Superior Court judge reviews the record, reviews the board's determination on the discipline that's proposed to be imposed on the licensee. And then at that point, the Superior Court judge would file an order, sign an order, either upholding or sending the case back to us for additional review. So that's kind of the process that a licensee has and the steps that you go through to resolve these disciplinary matters. One of the hardest parts, in my opinion, on working with the investigative committee is trying to figure out what to do. There's just so many different factors in these cases. Usually nothing seems to be, well, sometimes it is, but usually it's just not cut and dry. There's all levels of gray, and what you see on the screen here are the options that the board has to discipline someone. The first one there you see is not formal discipline and is used a good bit, and that's an advisory letter. The advisory letter is not reported to the National Data Bank. It does go in the licensee's file and can be used in the future if another complaint is filed against someone and would be considered if there's multiple complaints. Technically this isn't formal discipline, but we typically do ask that the licensee, if they accept an advisory letter, that they pay the costs. And they can refuse to do that because it's not formal discipline. So the statute doesn't require that they pay the cost, but a lot of times we can agree that they do that. And by cost, what I mean is costs of the investigation, what it's cost the board to look into everything. The next level would be a warning. This is formal discipline. It can or does not have to have additional requirements involved, but it is reported to the National Data Bank. We always ask that they pay the costs, and in the letter it will lay out what they have done, and that obviously is used in the future if anything else is filed. Next will be probation. There are limits on what you can do with probation. It can't be longer than 3 years. You can put various requirements as far as additional training, who they can and can't practice with, where they can and can't practice. You can, depending on what the allegations are, you can do all sorts of things to try to address the issues. A suspension would be a period of time when the licensee can't work. That's also a situation where you would charge costs to the licensee, and then the revocation obviously is the license is revoked. I'm not, that happens on occasion, but it's not all that common. And then finally, you can also refuse to renew someone, and that usually happens when there's something kind of hanging out there that needs to be done that hasn't been done yet. One recent example I could think of was, there was someone who didn't want to practice anymore. The board needed some proof of continuing competence. They also received a warning, but in addition to the warning, there's a refuse to renew. If the person ever did want to become licensed again, they would have to go back and do certain things before they could be renewed.
Excuse me, David. Refuse to renew is not a disciplinary action.
That's correct. It's not a disciplinary action. It's just something we could add to, some of these other things to place additional burdens on the licensee.
David, in addition to that, do you want to say anything else about some of the conditions that we have placed on licensees, most often with probation and suspension? Because, just not being able to practice for a certain time typically isn't all that goes along with the probation,
right,
suspension.
There's almost always conditions, and it really depends on what the allegations are. But for example, if the issue had to do with improper billing or improper note keeping, treatment note keeping, a lot of times the investigative committee would suggest that they complete a certain number of hours of continuing competence in that specific area within a certain amount of time and provide proof to us that they've completed it. That's one example. The other examples would be that they can't supervise, depending on what the allegations are, they can't supervise folks for a certain amount of time. I don't know, can you think of any other examples, Kathy, that you want to throw?
Yes, especially with billing and documentation issues, they are required to have their physical therapist supervisor provide a quarterly report that they are, completing their documentation, it's accurate, compliant, and they're complying with aspects of the Practice Act and rules, and that's certified by their supervisor sending a quarterly report. Sometimes they have to do some external counseling or some kind of check-in, and they're required to have that person who's supervising them submit regular documentation about that. I think the other thing that this is just to bring up for those that have been attending some of the Federation regulatory trainings, maybe not so much this year, but in the past when they were talking about like the model action guidelines, I think the emphasis is on remediation. And so trying to assist a licensee who has had some violation in educating them about how to avoid that kind of issue in the future is an important component. And I think we've been definitely trying to add that as we go along. Similarly with, competence issues, which we don't have quite as many of, but, we would want to have them demonstrate some kind of remediation with that as well.
Right.
And David, this is Teresa. Are you going to talk about impaired practitioner
Yes.
and referrals to the DON?
I'm glad you mentioned that, and it's not on my slide, but one other thing that I did want to mention is when we do receive a complaint alleging some sort of impaired practice or some violation that they've done that was caused by substance abuse, we, the investigative committee, will review those allegations. And if in fact it appears that substance abuse is the issue, and this is right in the board rules and the statute, we as the board can refer them to a program which will hopefully rehabilitate them. And during that process, if they're willing to go into the program, sign an agreement to do an exhaustive agreement to do a bunch of stuff, which I'll go over in just a second. The investigation process inside the investigative committee is essentially put on hold while that occurs. And since the PT board doesn't have a ton of these, what we have done is contracted with the North Carolina Board of Nursing, who does have a lot of these issues, to administer the program. So they have what's essentially a separate arm of their board that just deals with these types of contracts. And they'll sign a contract with the licensee. The licensee has to go through many, many steps to be approved and successfully complete the agreement. And then once that occurs, that it is reported back to us that they've completed it, we'll review it at that time. And then most likely the disciplinary matter will be dismissed against them if they've successfully completed. We've got one licensee in that process right now. And that's all I'm aware of as far as any pending matters that are with the Board of Nursing. But if you're interested, I'll send you an example of one of these contracts. It is a lot of work to be able to successfully complete one of these things, and the licensee has to take it very seriously. If they don't complete it successfully, what happens is it comes back to the investigative committee and the investigation continues just like it would for any other complaint. So they can try, and if they're not successful, then they come back, and then you as the board may be seeing these things just like you would for any other complaint. It's not until successful completion that the matter is dismissed. This next slide, we just talked about that. There's many other things you can do to place restrictions and conditions on a licensee. And the goal here and underlying all of this is to rehabilitate the licensee and not just punish them. I think we all have to remind ourselves that we're trying to correct the issue and address all of the matters in the allegations rather than just say, here's your punishment and move on. So we do try to tailor our suggestions using that principle. And that is it as far as my slides. Anybody have any questions or anything I missed?
I'd like to add that as a responsibility of joining the Physical Therapy Compact, our board has the responsibility to report various things to the Compact Commission. And that includes any kind of what's known as encumbrance. So for example, someone might have to pay costs of the investigation. There may not be other kind of discipline, but we have to report that as an encumbrance because that limits someone's eligibility for a compact privilege. We also have to report disciplinary actions, investigative, whether someone's under investigation, but only at a certain point. And then we also have to remove those things from the Compact Commission database when they're either dismissed or action is taken. We also have the responsibility to share investigative information if someone from another state has a complaint against them that we believe has probable cause. The other state may also want to take action. We fortunately haven't had that situation occur here, but it's part of the idea of the compact that people can't just move to different states because they've got something adverse going on in one state and the other states not know about it. So it's part of our obligation. So we haven't really done a lot of dealing with that yet, and it's not in our rules specifically, but it is in the PT Compact rules. So, it's just another slightly different aspect to the investigative process that we also have responsibility for.
Gotcha. And I think that is it for the attorney's report. I'll turn it back to you, Madam Chair.
Okay, thank you, David. Are there any questions by any board members for our board attorney, David Gadd?
Yeah, I just had one question about advisory letters. So when someone is trying to get credentialed to a hospital, since it's not formal discipline, would they be required to put that down? Because not all, sometimes, correct me if I'm wrong, some advisory letters are not necessarily due to practice infringements.
Right. No, I don't think so. I mean, I think that if the application specifically says, have you ever had an advisory letter, then it would be on them as to how they need to answer that question. But if it says if they've ever had formal discipline, I think the answer is no, they don't have to report that. It's purely a private correspondence between us and them.
Thank you, David. Any other questions for David? Hearing none, I think we'll move on then, Kathy, to your executive director's report.
Okay.
This is section G on the agenda for those of you following.
Correct. If anybody's had any updates to their address, we've just recently added Rose's change of address to this form. So you may want to take a look at that if you have any need of that. We also have the most recent licensee count. And, if you've already taken a look at that, the licensee count at this time has an increase of 2.44%. And that is slightly less than what it has been. And, as we've mentioned at multiple meetings, this was expected that giant increase was due to a lot of new programs. But, it's slowly decreasing, but we still, it hasn't fallen to zero. I think with the temporary exemptions, we're not counting that in this licensee count. So that's about 300 people that we have right now. So we do have, you know, some additional licensees practicing in the state, but they don't have a full license. Excuse me. I think we specifically chose to add PT compact privileges. So you can see that in comparison to last year. And then military permits. And I think the reason that you see that as being a higher number than before, you know, over double what we had in 2020, was because they were getting licensed before the permit was being issued. And if they didn't, so they didn't need a permit. And now we're issuing that permit due to some changes in the state law. We're just issuing the permit, and you know, one way or the other, even if they use it, even if they don't use it, and then they're getting a license at a later point. So that's the change there. Jamie had asked that we provide some information about failure rates. And so, you know, we provided that without a lot of context. And so if you took a look at that, first thing that you might want to notice is that it was provided with data between 2016 and 2021. So, and you can also see that there are a whole lot of schools from which we receive applications. And so this is just a lot of data to sift through. And, you know, in providing that, I think Jamie and I had kind of a sidebar conversation, but Jamie, if you wouldn't mind sharing what your thinking was about us providing that information, that might be helpful to everyone.
Yeah, I had just been looking at that whole form, and where it had the exam pass rate, it was cumulative, where the others weren't cumulative, they were by year. So I couldn't make any sense out of that continuing number. So she included later also a report of each school and what the pass rate is per school in a later attachment. So you can just follow over time. And basically the pass rate is pretty high, less than 10% fail from each school. And then some of them have an ultimate pass rate of 100. But I was just curious about it, looking at the other data that was provided on that form.
Yeah, so there's probably a little too much information in this fail report that we provided to you, but at least, you know, if you wanted to look at the North Carolina schools specifically, it's in there by school, and you can see, you know, down when we talk about the schools, you can always see the ultimate pass rate gets close to 100%. And North Carolina typically for PT programs is above the national average for first-time pass rates. And PTA programs are usually at or above as well. And we always pay attention to those that seem to have a significantly lower initial pass rate, and ask them to let us know, you know, how they are addressing that. You know, as the PT board, it's more about trying to help support them and provide them resources if we can, and just letting them know that, you know, the board's out here if we can be useful to them. So
one thing that I noticed when I was looking at the reports, though, was that all schools had a problem in 2020. I think with when COVID first started, their pass rates went way down, and I couldn't tell if most of those had gone back and those students then ultimately did pass, but they were up to near 50% fail rate that year.
You know, oh, sorry, go ahead.
I was going to say across the board, not just, you know, usually new schools have a higher when they just start. So it looks like that initially those students had a hard time with that last year being distance education, or something was missing that they couldn't get across with the switch.
I think we really have to just use a little bit of caution in looking at some of that information, just because there are so many factors that play into this, over which, we don't have any control. And certainly the spread out test dates and the worry on the part of those students to, even just sit for the exam, and so I would use a lot of caution. I would need to ask an awful lot more questions that would have to be supported by data to really determine that there's anything going on the part of the schools, before we would say anything about that. It's just another way to slice the information, and we're glad to provide it if we have it. So, please keep asking. You maybe had an opportunity to take a look at some revised goals and priorities for the next, excuse me, until June. And, I've color coded what we've been able to accomplish, what's in process, and, or any revisions that I had access to at the time. As everybody can imagine, we're still working on adjustments and modernizing things as a result of COVID and remote work. But I think we've made tremendous progress since this all started, and there's been an awful lot accomplished. So I think, just taking a quick look at that, I think is helpful. Also, to inform you, should you as a board want to have the staff focus on specific areas, I think it's helpful to know where we are in process, and then you can task the staff to add some additional items. So does anybody have any comments or questions about the current set of goals?
I just think it's really amazing what the board has been able to accomplish, the staff, with the rapid requirement of change and technology and all the adaptation. So I commend you and the team, Kathy.
Well, thank you. And I'm handing that all off to the staff. I mean, in particular, licensing and the support of the IT department. I mean, yeah, just a lot of heavy lifting's gone on, and they've done a fantastic job. So thanks for acknowledging that. Renewal statistics, basically, to summarize here, we had a 95% renewal rate of over 14,000 licensees this year. So that number, as that number grows, to me, it's amazing that we don't have more of a drop off, because I know with the compact, and especially with COVID and the ability for some other states for you to practice temporarily with an exemption, people are moving around a lot, but they're still also doing a lot of renewing in North Carolina. I added this Missouri workforce report just because it was sent out, and I think it's really interesting. Some states on a statewide level have a mandate to provide their workforce data. And I think that's interesting, because as a licensure board, we are the only entity that can collect 100% of information. If you just send out a survey, you might get a 30% return on what's going on with your workforce. But in order to plan for the future, you have to know what's happening, now, and where people are working. And I believe they use the PTMDS. So, one of my aspirations is to work with the chefs and see if we can't put some more robust information on the chef's website about our data collection, because we changed it this year. And we do have more information about where PTs are located, and with more emphasis on diversity and inclusion and equity of providing healthcare, connecting the types of healthcare workers to the need is is useful. And so otherwise, I think that's the reason we collect it. And as regulators, we can have a positive impact on health. So,
and Kathy, does everybody know what SHEPS is?
I don't know. SHEPS is SHEPS is the name of a professor, I think, at the University of North Carolina, our former professor. And there's they have a separate center that collects workforce data and does research specifically about healthcare professions. I think they also probably work with the School of Public Health at UNC. And so they house all of this information. And so if different groups would like to access information, I mean, it can be anything, medicine, nursing, PT, other occupational healthcare occupation professions data, they can go directly to SHEPS. They don't have to seek it from us. They can get it directly from SHEPS with our permission and use that information for research as it relates to, whatever that is they're trying to figure out. And I know that the PT data has been used historically in a couple of cases, but I think PTs, as we try to educate the public about our primary care role in, being able to see patients without physician referral, and, as it applies to our scope, I think it's important to know more about our profession in the state and then be able to provide that information as it's necessary. And so, if it's easy, we send this information to Tony Kane. Currently, they lost their person that worked directly with us to needing to be at home during COVID. So they're getting some new staffing, but hopefully we can do that with this new data we've collected, so it can be useful. The second or the next several items, this is communications with the Department of Health and Human Services, some interaction I had with a Duke physician, and then, as we talked about before, Jill Forsena, which I've spelled Joel. I need to correct that. It's Jill. All related to efforts to more proactively determine how what the PT board could do, if anything, to connect PTs with where they can be useful in not only vaccinations but other means. And so David Gadd helped connect us with Amanda Moore. And so we just sent her some information about, we've got this database. How could we be helpful to the state of North Carolina in using it? And it's sort of progressed from there. Some of this initial information sharing as the vaccination effort is rolled out, I think it's boiled down into this last document, which I prepared, which is that considerations for regulatory flexibility. And the executive order that David discussed earlier, we need to address the specific things in the executive order and then make whatever recommendations or information we want to provide. We need to post that on our website so that people have access to it and then can take advantage of that as it's appropriate for them. So it does require discussion and possible motion about final recommendations. So the discussion needs to initially center around, would the board consider waiving or modifying regulations allowing licensees from other states to provide vaccinations in North Carolina? The retired or inactive licensees, unlicensed volunteers, and students. And I think first, I just need to say, does anybody have any initial comments and anything that's different from the recommendations that we talked about earlier?
I would just want to make sure I understand. It also includes, you said, current licensees can give the vaccine is what it's going to permit.
Yeah, and I think because we've determined that it's not within the PT scope, it's not physical therapy when you're providing vaccinations. But if you want to do it, the board is not going to say that it's a violation of the Practice Act, but you have to obtain the proper education, training, and competence to do it and follow all other applicable state laws in order to do it. But the board is not, it's not going to be a violation for you to do that.
From what I looked at, that seems reasonable, especially with that training requirement. And then, like Rosa said, they may or may not need us anyway, but if they did, then I think it's appropriate that PTs could do that.
And Kathy, if I can chime in real
Please.
briefly, I don't know that if the board determines it's not within the scope, then we don't really need to waive any regulations. All we're doing is saying that, as long as you're properly trained, it's not going to be a violation of any of our rules.
But they have to make sure that it's not under the physical therapy, their license in physical therapy, that is other than that, right?
I'm sorry, Pearl, could you say that again?
So it won't be under their license as physical therapists. It's just, you decide to do this, you got the training, and you can do it under that reason, right?
Right.
Okay.
Yeah, I agree with that. Yeah, it wouldn't be a violation of anything that the board has control over. And because of that, there's really no regulations for us to waive or to modify.
They need to include some kind of language as not holding yourself out to be a PT while you're doing it.
So down here, or if you scroll down in that document that I prepared, in the box, there's the current response that we've provided to people, but we can add, that you're not calling it physical therapy, you're not calling yourself a therapist, so you're not billing for it, that kind of stuff, the usual statement that we include. And then also to follow all other applicable state laws, which then it's their responsibility to determine, because the board doesn't have the authority to administer the North Carolina Medical Practice Act. So those are two additions that I might recommend in what we post and what I send in the future.
And David, to your point, in the little box on page 2 and 3, it does say, nor is a PT license being used when providing the vaccination. So referring to yourself as a PT would not be done.
I didn't see that.
Yeah.
I actually, I guess it has to say that. I kind of wish it didn't, because I think it helps our profession to say we're trained therapists, but working outside of our role to help in this time of need. We're not billing as PTs or working, but we are therapists out here helping during the COVID crisis.
I think I don't disagree with that statement. I think from a legal point of view, I don't know that we can do that, because then we're saying two different things at the same time. If it's not in our scope, it's not in our scope.
Right. Do you need a board motion to accept this, Kathy? A board vote?
Well, David Gadd, if you don't mind helping me with this, I think since we're saying it's not in the scope and we don't have to waive it, I probably don't need a motion.
I don't think it's formally required, but I do like the idea of having some sort of action saying that this is how we want to proceed, that we don't think it's within the scope. However, when dealing with these kind of questions, this is how we answer it, and we can also post this on the website. I do like that idea.
Okay, the chair would entertain a motion.
I motion that we accept this recommendation.
Second.
There's been a motion made and seconded to accept this letter written by the executive director and approval of the contents. Is there further discussion? Hearing none, are you ready for a vote? All those in favor, let it be known by saying aye.
Aye.
All those opposed, please say no. Hearing no objection. Oh, anybody abstaining? I forgot about that one. Abstaining. Then the motion carries at 100%. Thank you very much. Kathy?
Thank you. And so we'll revise the statement in response to people's questions, post that on the website in addition to the information about where they might be able to obtain training for vaccinations and other volunteer options just through the state. Okay. This is an FYI. We've made some updates to the personnel policies, and those are there for your review. They've been reviewed by the staff and signed off that everyone has received them and that they understand them, and we're implementing them now, in part due to our payroll audit and just changing the record keeping so that it's a little cleaner going forward. We have updated the temporary exemptions. And then I also added for your information some guidance that David Gadd provided me with in response to questions about people asking when their exemption from licensure expires. And so I had been consistently saying that it's when the state of emergency ends, but in the Practice Act, it says until the end of the renewal. But in David's interpretation, which you see in that document, what I've been saying is accurate, that it is when the state of emergency ends in North Carolina. So this could continue on for a while. And the reason why that's really important is because we have over 300 people with these exemptions right now. And I'm going to give a huge shout out to Kim Jackson, who has been managing that on an everyday basis. She, sends all of them the official letter. We're record keeping on it. She responds to their questions, and if she can't answer them, she sends them to me. But it's kind of like having 300 more licensees that you have to track and keep aware of. A number of people have been using this as a way to get a license or the ability to practice more quickly while they're waiting for their full licensure. And so as those individuals who had an exemption become licensed, they are removed from that list. So it's actually been more than 300 over time. I think it's just those people are on and off the list depending on their status.
And thank you for organizing that alphabetically.
And thank you, Teresa, for requesting that. It's a PDF, and you can also search it. So I think that is more helpful to the public looking that up. So thank you for that. The next item is following up from the December 2020 board meeting, and again, another topic in regulatory flexibility regarding whether we were going to make an alteration for the renewal fees for 2020. I've decided that I haven't had a chance to process the effects of the renewal and the renewal fees, and I would like to move that to the Finance and Audit Committee to review and make a recommendation to the full board at its June meeting when we consider the budget. So I think that may be a more appropriate time to look at that one. So I'd like to move that to June. CAI is our HR consultant company, and they have changed names and they've now become Catapult. I think they're offering broader services throughout the state, and they've changed their name. We still are working with Carolyn Harris as our consultant, and we use her as we need her, which is intermittent. But it's good to have them as a resource for all kinds of things, and certainly as we consider what's going to happen with work as people become vaccinated, and what we're going to do about the office and whether we're going to stay remote or come back or whatever. Having membership in that organization will be very helpful to us, so we're not reinventing the wheel. Last on my list today, and then I do have one new addition that came in the other day. Predetermination is a term that was added to a state statute for occupational licensing boards, where an individual who has a criminal history can petition a board for the board to make a predetermination about whether they can be licensed prior to them ever completing school or filing an application and that kind of thing. And we recently, that law was passed in, let's say, 2018, I think. And we hadn't had an official request until now. So David, Gad, and Debbie and Kim helped me pull together an application form by which this individual can submit his official request, and they would be subject to submitting a we've obtained a criminal background check on that person, and then they need to submit all their documents probably in a very similar fashion to what they would do on the regular application anyway. I think in the statute it says that it can be delegated to the executive director, but we're going to continue to work with David Gadd and use his guidance to help us when this individual eventually submits his application. But right now we're at the phase where he's requested it. We've sent him the documents to complete and gather the information, and it's resubmit to us. So I may have an update on that for you in June. I think the concern, and for those of you who were on the board when John Silverstein was our attorney, we talked about that, and the concern previously was that having one board make a decision for a future board, you couldn't hold the future board to what this current board was doing, but this is what this law allows to be done. And it would only be that if the person met the conditions and nothing else about it had changed, could we then say that they could obtain a license in a future time frame. And this person is going through this process to determine whether he should try to go to school and to get a license before he spends the time and money and effort to do that.
There's also, Kathy, a very strict timeline on how soon we have to get back to him under the statute, which I thought was interesting because, a lot of times board meetings don't happen during that time. So what the statute has done is gone through and says, the board can make the determination. However, if it can't be done within the timeline, the board shall give the executive director or a committee the authority to make the determination as long as it's done within the timeline. And I think it's 60 days. I have to look to be sure, but.
So do we need to make an official motion about that authority, or?
So let's have a little discussion now. I mean, do we want to have a predetermination committee, or does the board want to give you the authority as executive director to make the predetermination in the event the board doesn't meet within that 60-day period when an application comes in?
I think Kathy would be more than competent in making that decision without having a whole committee to talk about those issues.
Right.
I
That's
agree.
right. Am
Do
I
you need
hearing
a
a
motion?
Yeah, hear a motion? Pearl?
I wonder though, Kathy, would you, I think you're certainly competent because you direct it, but would you prefer it be a committee because you are making that decision for the whole board that holds in the future?
Well, I think that's a great question. And that's one of the reasons why I feel like I want to review it again. And I think the authority now is good in case this gentleman submits his application tomorrow, because it's going to be 60 days before the board meets again.
Right.
I might want to come back after we go through all of this and we determine what the process is. I mean, it's pretty clearly outlined in the statute, what factors you have to consider. But you know, I may want to come back to you and say, I think you should have this committee in place, and then, you know, use it if we need it. I don't know that I can answer it because I haven't done it yet.
Right.
So he's saying after you make that, after you see this first application and you do what's needed for that, then you can come back to the board and report, yes, we need a committee to do this. No, this is something that I can do, or whatever the process may be, because you've been through it and you can tell us. Is that right?
That is what I'm saying, correct. Mm-hmm.
And looking at the information that is there, it looks like information that's very similar to what the investigative board looks at. And I was thinking that would be a good committee that's already standing then to refer it to. And I don't know if you can call like an emergency quick meeting of that committee to go through it, but it looks like it's very similar issues,
But is
at
that
least in this case.
committee, is that an investigative committee duty to have something of this sort? You know what I'm saying?
Yeah,
You could
I
assign it to that committee if you wanted to.
I think seeing as this is the first predetermination request we have had, that it makes sense to gather the information. And I really like the application or format that you all came up with, Kathy, because I think it's really comprehensive. Because we may need to get our PI involved or look up the details of his F1 sexual assault felony to determine more. So those are discussions that are typical in the investigative committee.
Okay, so we could make a recommendation now to have those predeterminations referred to the investigative committee for a recommendation back to the applicant.
And we already have a mechanism for sending those records to the investigative committee for review before meetings. So that process is already in place.
That's true. And we have, you know, already the attorney assistants and investigator there. So,
yeah.
David, would you think that that's reasonable?
Sure. Yeah, I think the investigative committee
All right.
Would be fine to handle that.
Okay, do we need a motion about this?
I think so.
Okay.
So I'll make the motion on, Kathy, how did you put those words?
That we refer predetermination applications to the investigative committee for review and decision. I can write it down, Pearl.
Please, that's my recommendation.
I second Pearl's motion in formation.
Okay, so we have a motion and a second to refer predetermination applications to the executive committee for decision. Is there further discussion or question? Are you ready for the vote? All those in favor, please let it be known by saying aye.
Aye.
Aye. All those opposed, no. Anyone abstaining? The motion carries. I think at this point we are like 8 minutes away from our closed session. So I'd like to call a brief recess. And the order of the day is we need a motion to adjourn this.
Actually, we're going to go to the public hearing.
The public hearing. Yeah. So,
I don't think we have to adjourn. We can just take a break.
Okay, let's take an 8-minute break and come back at 9:59. And then we're still on the same Zoom, right?
Correct. Yeah.
Okay.
So you can just, put yourself on mute, close out your camera, and then come back.
Okay, we'll see you all in 8 minutes. Okay, it's 10 o'clock. Is everybody back? Missing Crystal.
Yeah, Crystal's here.
Oh, there's Crystal. Okay, looks like everybody's back. So let's go into our public hearing for permanent rulemaking. Debbie Reagan, do you want to introduce this?
We are still in our public comment period for permanent rulemaking. It will end on March the 16th of 2021, but we are required to have a public hearing should any member of the board or any member of the interested parties or community wish to speak with regard to these proposed permanent rules.
And so at this point, we are required to read what the rule changes are so that it is in the public record and so that we then can consider any public comments. So this is a public hearing on rule changes. On January the 15th of 2021, the North Carolina Registry contained the notice of proposed rulemaking proceedings, scheduling the hearing for today and the subject matter to be addressed at that hearing, namely to amend the following rules, which are cited as 21 NCAC 48D.0107, 0109, 0111, and 0101. The reasons for the proposed action were stated in the notice of hearing, which also included the rules themselves and the notice of the public hearing to be held today at 10 o'clock via Zoom remote meetings. And I would note for the record that the time is now 10:03. Comment procedures indicated that any comments could be submitted in writing to Debbie Reagan, the Deputy Director of the Board, up until March the 16th of 2021. And at this time, I will ask Ms. Reagan if any written comments regarding the rules have been received thus far.
Madam Chair, we have received the following comment. Dear Ms. Reagan, I am writing to object to making the temporary rules adopted by the North Carolina Board of PT Examiners permanent. The rules being defined by the Governor's Executive Order 116, Section 16. I have close personal colleagues throughout the state of North Carolina, both PTA as well as PT. During the COVID crisis that still grips our state and country, the field and discipline known as physical therapy, including PT and PTA, has seen a significant contraction in terms of jobs and working hours for many of those PTs and PTAs that are still employed. I can personally name 11 PTAs and PTs that have lost their jobs entirely due to layoffs from the virus, and those 11 can in turn name others. The fact is, in facilities that have been hit hardest by the pandemic, skilled nursing facilities, therapy, and therapist and assistant usage has been minimized, resulting in job loss as well as reduced hours meeting patient needs. Outpatient facilities have also minimized staffing as well, in some instances resulting in layoffs and job loss. Hospitals are reluctant to utilize PT or PTA beyond their scope of practice, thereby limiting their usage in that setting. There is no need to continue bringing other licensed individuals from out of state to meet a need that, judging by the number of professionals losing their jobs and losing work time does not exist when we have an excess of licensed individuals within the state that can and are anxious and more adequately meet and exceed the needs and demands of our patients. I know that in my region of Western North Carolina, when a job vacancy is posted, there are a very large number of applicants for each job, both PT and PTA, and those applicants are already licensed and living in North Carolina. Thank you for your consideration to my objection. Sincerely, Jerry Tedder.
The rule or the notice published in the registry also indicates that the rules do not involve the expenditure or revenues and state or local government funds. The reason for the proposed action states, these rules were previously adopted as temporary rules by the Board of PT Examiners. The board is seeking to make these rules permanent. On March the 10th, 2020, that was a year ago, the governor of North Carolina, by issuing Executive Order number 116, declared a state of emergency to coordinate a response and enact protective measures to help prevent the spread of COVID-19. The World Health Organization, the Center of Disease Control and Prevention, and the United States Department of Health and Human Services declared COVID-19 a public health threat and emergency. Section 16 of Executive Order number 116 temporarily waives licensure requirements for healthcare providers licensed in other states, territories, and the District of Columbia. The North Carolina Board of PT Examiners seeks to help increase the pool of qualified healthcare providers who can provide assistance with a COVID-19 outbreak by creating an expedited process by which physical therapists and physical therapist assistants can be licensed. Furthermore, qualified physical therapists and physical therapist assistants will be essential in the rehabilitative process for many persons recovering from the residual effects of COVID-19. The proposed effective date for these rules is August 1st, 2021. It is always appropriate at a hearing of this nature to hear from any citizens who have attended the meeting. Is there anyone in attendance who wishes to speak? And if so, please state your name and your address.
We have no pending participants or anyone waiting in the Zoom with comments.
David Knoll, thank you for monitoring any members of the public who may have expressed a desire to speak. Therefore, do any members of the board have any comments that you would like to make on these rules? If not, then I think it would be appropriate for the board to close this public hearing aspect and to discuss what they would like to do with regard to the implementation of the proposed rules. I would note that for the record, the public hearing portion of this meeting is closed at 10:08 a.m. Debbie?
Thank you. The next steps for this, again, the public comment period will be closed on March the 16th, 2021. We have received one complaint so far, our public comment, and we hope not to receive any more. We will be able to close that session and hope that we don't get 10. We will put these rules before you in June so that you can adopt the rules at the June 9th, 2021 board meeting. We will then submit them to the Rules Review Commission for their consideration. They will review them at their July 15th meeting. We assume it will go well and with an effective date of August the 1st of 2021.
And Debbie, I'd like to ask you a question about what is our procedure for responding back to the one public comment we received?
Our standard response is, thank you for your comment. It will be shared with the board.
Okay, are there any other questions of our Deputy Director, Debbie Reagan?
I have one question. Ms. Reagan, the objection we received seems to be general in nature. Are you aware of any specific objection to any one of these, the language in the specific rules that are proposed to be changed?
No, sir.
Okay.
And the public comment on these rules will be ending March 16th. So that's coming up very shortly. Okay, I think we'll move on, Kathy, to your executive report, beginning with on the financial report, I'm sorry, with your executive summary.
Okay.
This would be letter H in the agenda.
Yeah, I've got one thing that I didn't have in G that I just want to mention in case anybody didn't receive it. As you may remember, annually, the state of North Carolina occupational licensing boards hold some training. And when it was being done in person, it was done at the bar building, and they have limited space. So we could only bring a limited number of people to that meeting. This year, it's going to be held virtually. And so everyone can obtain some additional regulatory training. I sent the preliminary memo in case you want to put it on your calendar for May 18th, and you can attend as much or as little of it as you'd like. But it's open to everyone, and I just wanted to be clear about that. You know, it's topics, speakers, issues that relate to the regulation of occupational licensing in North Carolina, and I always find it very interesting. So, you know, you may as well. Another opportunity for more education about your role as a regulator.
And I'd like to endorse that meeting. I actually attended, I guess it was 2 years ago when it was in person. It was fascinating to be in the room with other occupational licensing board members, and to find out how much we have in common with the locksmith board and the plumbing board and the other healthcare boards. So if you've never attended, I would definitely encourage you to participate in that OLB training.
Is that something we have to register for?
Well, he hasn't sent out the registration information. I imagine there may be a registration, especially if they're going to do it on a Zoom where they have to admit people to the meeting. You know, they need to know who the registrants are. But honestly, Pearl, it's Bob Brooks from the CPA board who always does a fantastic effort at pulling this all together. So I'll be forwarding that to you as soon as I get it.
Okay.
Okay, so moving on to the financial report. I think what I'd like to do is jump right into the profit and loss statement for your review and comparison to last year. And this is the time of year where, you know, we've just finished renewals. And so, you know, this is the time when the board has probably, you know, the most money that it will have during the year. And so if you look at the first page of the profit and loss, and you look at about halfway down the page for total PT renewals, you can look at that number in comparison to the number from last year. And so that's about a 3.8% increase. You know, looking at our licensee count, you know, we talked about 2.5% basically was an increase in the licensee count totally. You know, renewals only represents a portion of the revenue that we receive from licensure fees. The other comes from applications, be it exam or endorsement, and so that all that makes up the increase there. Revivals are also up over last year. I think that's just a reflection again of the total licensee population that we have here in North Carolina now. And
is everybody able to look at that P&L?
No, all right.
No, it's not here.
So let's.
We've got a balance sheet. All right, and a budget, but the P&L is not attached.
Well, then let's get that in there.
Yeah, I was looking at the balance sheet, not the.
I'm sorry. All right, to refresh your screen and then see if you can get it now. If you scroll down, you know, you click open the item and then scroll down, there should be an attachment. David, I see David nodding.
Yes.
Bill's nodding.
Yes.
Okay, everybody getting it now? Okay.
Got it.
I apologize for that. So again, looking at page 1, and this is our biggest time of year where we've just kind of gone through the renewal phase, and about halfway down the first page, you see on the left-hand side where it says total PT renewals, and you can look at the comparison of this period between July 1 and February 22nd of this year to the same period last year.
Wow. So a lot more people are renewing online.
Well, and that's a requirement. We also eliminated the purchase by check this year. We went with e-check as opposed to paper checks, which I will say from an internal processing point of view is a little bit of a double-edged sword. We have an agreement with a third-party vendor so that we don't hold on to anybody's credit card information. They also did the processing of the e-checks. What they don't do with the e-checks, though, is they can't get a real-time update on whether that check's going to clear or not. So if anybody makes a boo-boo in number entry or anything like that, they kick it back and we automatically get charged for it. Cindy had a lot of work to do to track that down, communicate with the licensee that it appeared didn't pay, but they really, it was the correct intention. It's just the payment didn't go through. And so, there was a lot of work that was added. So it didn't appear to be the most efficient way to go about providing people with an alternative to a credit card. That's going to be one of the things we'll look at for next year. But we did it all online this time. So with some additional work with those changes, we've taken in some additional money again because our licensee count is up. 95% of 14,000 is a little more than 95% of 13,000, which was where we were last year. So that's what accounts for that. And then you can look at the other income categories, from our other application type of income. Compact privileges, we're paid $50 on a monthly basis for the number of compact privileges that have been purchased in North Carolina. That goes through the commission and then that's sent to us. So, not a huge number, but, we're taking in the application fee from that. And then if you scroll to the next page, you can look about a quarter of the way down. There's total income in comparison to last year. And not a tremendous difference between this year and last year. So, this also is a reflection on the fact that, we've got these 300 temporary exemptions in North Carolina, but they don't pay anything. And then we're not charging for the licensee lists anymore. That was a board decision that was made. We're not charging for retake fees, other kinds of things that we're not charging for that, are not huge amounts of money, but, it all contributes to, slightly less income. And then, if you look down in the expense column, we've continued to add employees. Which then alters our benefits and our payroll taxes and that sort of thing. We've added some contract labor, which has increased that category. On the converse side, if you look at the board members and board related types of meetings and travel and that sort of thing, that of course is going to be significantly down, and that reason is obvious because we're handling things remotely. Disciplinary expenses, the investigator expenses are down significantly also because he has conducted most of his investigations and interviews remotely, and only done a little bit of travel. IT is probably going to be up because as the board voted, we're trying to beef up our technology and leverage technology to make the office processes more efficient. So that again is not a surprise. Our office supplies, though, are down a bit because, again, we're trying to minimize paper and minimize those kinds of, supplies that we use. The credit card fees are probably about as expected. And then we don't really have, our attorney's fees again are about as expected as well. I feel like those should be really high based on how many times a day I call David Cat, but that's about as expected as well. So when you look at the net income, it's slightly down, and I think that has to do with the fact that we are spending more on technology and we have more people than we had previously. And I think with the changes that we're making and making the office more efficient, we have not added the monies that the board had approved for technology into this budget. So it looks like a little bit less, but I think we're doing well. At the end of the year, if you might remember from the audit, we have significant amount of money we've made up for the expenses that we had incurred during the lawsuit. And so we have a very healthy reserve. So does anybody have any questions about that? Moving on, the balance sheet is, more of a summary of the monies that we have and where they're located. We have been working on closing a number of accounts and doing some consolidating into Pinnacle. That work continues. Cindy is doing that as the time-based types of accounts are able to be closed. So you'll see that change probably more significantly in June as she's got time to finish with closing the accounts. And then just some other categories of, for whatever reason, furniture and computer equipment is put together in terms of fixed assets. And so, again, we've talked about the fact that we've definitely been adding some new equipment. We bought a server recently, to the tune of like $12,000, and then just needing new computers and updates and upgrades for people working at home. So that's very explainable and not nothing unusual there. And then the liabilities this is more payroll in here. And then under equity, these are our accounts that are in reserves. And so some of them are reserves, I guess I should say. And those reserve accounts are there for the fact that we know that we're going to be spending some money in those areas, and we've got those monies available, when we need them. If they either budgeted or unbudgeted, we can move the money from the reserve into the budget to use for those necessary expenses. So again, anybody have any questions about the balance sheet and where we stand?
Very healthy.
Looks good.
Looks really good.
Then the budget numbers are just there for your comparison, should you want to, look at those, and I'll be glad to answer any questions about that. The updated implementation of the financial recommendations, again, we've kind of covered that, in that Cindy's going to be continuing to work on that, but you'll see the total numbers of accounts decreasing over time as we consolidate, and those will change more, like I said, in June. And then this is a final, well, I called it a final report. I will say we still have some more actions to do, but we completed the payroll audit with a 3-year look back. You know, and just to refresh everybody, the reason for that was there were some irregularities in payroll as a result of some prior payroll vendor misunderstandings about the retirement plan, and then we had questions from the Department of Commerce related to our payroll tax filing. That has all been corrected, and so the Department of Commerce and the board we're completed with what we had to provide to them. We've got a new payroll vendor, which was a large upfront investment to get them started with us, but I think because they're certified public accountants, they certainly have the ability to really scrutinize everything that we do in payroll, and we have a lot more direct contact with them. They're more easily accessible than certainly we were when we were with a big company. I will say that it's pretty expensive, and so going forward into the next budget year, we're going to have to look at, you know, what we might do alternatively. I had some recommendations, and those were not able to take on new business at the time. So, you know, may want to revisit that as we go forward. Where we still have some action items left are related to our retirement plan and assuring that everybody's account has been fully funded, and if there were corrections that needed to be made, that we do them properly so that the plan is not in jeopardy in any way of you know, any contributions that we made at a time that was unexpected. So we're still working on that, but we want to do that properly. So that's taking a little more analysis. And we can bring back a report at the next meeting or when we get that completed. And the last one on this summary that I did is related to where it says non-exempt employees appear to have worked overtime for which they were not paid. We discovered that that really had to do with the time record keeping for that and how that was being analyzed. We've made a lot of changes related to that, and I think that's all been corrected moving forward. And we used our HR attorney, Mimi Sewell, to help us with those policies and procedures. And I think we're now on good standing going forward, and we won't have further questions about that. So does anybody have any questions related to, you know, what we did, why we did it, and what we've got to do to make sure that we're doing well going forward with our payroll? Okay, hearing none. Would you like me to move on to the Federation?
Yes, go ahead.
Okay. So these are just mostly announcements that I think everyone is mostly familiar with. Again, this year, the Federation has made a determination that everything's going to be remote from, you know, day one to the last day of the year. So we'll be attending the Leadership Issues Forum virtually. The Delegate Assembly will be virtual like it was last year. Teresa Hale is your delegate. Later today, we need to determine who the alternate delegate will be in case she's not able to attend. But it'll all be done virtually. News briefs, you know, they come out every month, and you can access them at these links on the website. So trying to make that easier for you. I always find there is so much information in those that is you know, interesting and useful that you know, I would encourage you to take a look at that. Again, this is another area where if you look at those and you don't know what our board is doing about some of these topics that come up, or you think that that would be good for our board to consider taking action on, or you want to bring it up as a topic, you know, don't hesitate to let me know what your thoughts are about those. FSBBT continued committee service. Crystal Osland, Chair of the Resolutions Committee this year. Do you have anything new to add about any actions that are coming there, or anything you can say?
As of right now, we hadn't really had anything come across, the standard stuff so far that, they present every year.
Mhm.
I imagine as it gets closer, we'll have more to discuss. I know last year for the virtual meeting, they tried to not bring anything that was going to require too much discussion or anything like that, just because the challenges with presenting. But, having done one virtual meeting now, I think they might feel a little bit more comfortable with it if there's anybody that has anything they feel important to bring forward this year.
Yeah.
So,
Yeah, good. I thought it was a good meeting last year. It was very well done.
yeah, I think they did a really good job with it. Everything went smoothly, and I think it gave everybody a good opportunity. It's tough when it's a large group on a virtual
Yes,
meeting.
absolutely. Okay. Debbie Reagan has been asked to be on the ELDD task force. They're taking a look at, what things they may want to do or change. And I think Debbie mentioned to me, I don't think that's changed, that they haven't yet had a meeting, have they, Debbie?
No, not yet.
Yeah. So we're excited to have her representing us on that committee, the exam licensure and disciplinary database for the Federation. And then I hope all of you are getting these emails, but they are having sort of two sets of educational trainings now. One is Dale Atkinson. Once every month, he's going to do a regulatory topic. And Dale's always interesting, always thought-provoking. Any of those you can join. I believe all of them are posted, so you can listen to them after the fact if you'd like. Great thing for a long car ride, a jog, whatever. But Dale's always good to listen to. Similarly, then there's also either a monthly or sometimes two just general regulatory webinars on all different kinds of topics. And so I've tried to put the links there for you so you can look and see what's coming up. There's a panel on practice advice, so I'm going to do that with a couple of other people. And practice advice in this scenario basically means answering scope of practice questions. And I think a lot of other states don't have, or feel like they don't have, the authority to do that as we do. And I kind of feel sorry for them because their regulated public doesn't have the ability to get answers to questions when things that they don't know about. And I think the purpose of this meeting is to try to help everybody understand how you could do that in a way that doesn't mean that you have to have your attorney answering those questions every single time. And so we're going to talk about how each state does it and what possible ways you could go about it. And then the FSBPT budget is included, just for your FYI. As you know, they've made an awful lot of changes. And they've reorganized. People have different titles, they're different staff, and they're becoming lean and mean, and similarly have tailored the budget to the areas that everybody felt was most important for regulation. APTA, again, these are kind of announcements for you. The newsletters, they hope to have a in-person fall conference. So board members are certainly able to attend, and the board can pay for those registration and attendance fees. I guess it remains to be seen whether that'll still happen, but I think that is their hope. And so, maybe put that on your calendar.
Kathy, excuse me. I was just going to tell you, tomorrow is one of those FSBPT talks at 4:00 on intriguing recent legal cases, which sounded interesting.
She's funny. Hysterical. Jennifer Semko, if you need a good laugh and as well as thinking of things that you don't normally think of as being related to regulation, Jennifer Semko is really awesome. Yes, I'd encourage anybody to attend that. I'm trying to find Cindy. She's saying that she's not in. And David Knoll, if you don't mind assisting Cindy to get back into the meeting, please, because I don't see her on my list. Thank you. It is also, just FYI, the 100th anniversary of the American Physical Therapy Association. And I think it's been quite disappointing to the, masses that, they can't participate in any functions live, because that's a big anniversary to be 100 years old. I remember when I first became a PT, I used to say, well, we're a really young profession. Well, can't quite say that anymore. So that's good.
There's a really cool book that you can buy from APTA that outlines the century, the centennial.
Oh, cool. Yeah, that's neat, David. Thank you for sharing that. Yeah, I talked to Pauline Flesh not long ago, and she said they were hoping that there was one thing that they could do in person, and I don't really know what that is, but APTA website, I'm sure, can provide that information.
And I just did combined sections online.
Mm.
And it certainly wasn't anything like being there in person, but I still thought they did a really good job with the live classes, and you could sort of participate. They had some follow-up sessions that were question and answers live, but then there was a whole lot of content that was to see on your own, pre-recorded. So there was a whole lot of things you could see and do with that.
Absolutely. And, to dovetail along with that, Mary Kay Hanna, who's the president of APTA-NC, currently published a list of all of the North Carolina licensee speakers that were at CSM. I mean, it was a huge spreadsheet. So there is a lot of talent and education in the licensee population in North Carolina, and we all should be very proud of that group, for sure.
Yes.
Yeah. Okay. And that is all I have for that.
Any other questions for Kathy in that category of APTA or APTA-NC? If not, we'll move on to the report from our Deputy Director, Ms. Reagan.
Okay. In the attachments, you'll see my report. I'm going to highlight a few things, one of which is really appreciate the board's cooperation and participation in the alternative approval pathway. We're continuing to make progress with that. We are now fully invested in that. The hybrid January and October exam dates are finished. That being said, we're proud that everyone has been oriented and now is working well within the SharePoint system. We researched the out-of-state schools who would not know that we are participating, and picked the top 15 that we get the most applicants from, especially neighboring states. And we have sent out information to them about the alternate approval pathway and our participation in it. And then we're handling on a as needed basis when a school, out-of-state school, sends in the information. That is our time to reach out and educate them on the alternate approval pathway. Some of the schools are already aware of it. But if you see, as we come up to the April exam, you may still see what looks like an education form with a prior date on it, but you will see an email behind that justifying that, because we wanted to educate people before we said, oh, no, we can't accept any of this. So we are still in that ongoing education, and we believe that it will continue to streamline and be a positive for both the students and for the board itself. Oh, I want to touch base on the military. In the prior, before December the 1st of 2020, military members, we encouraged them to get a permit. We worked with the military for their expedited process and offered them the military permit. But if they didn't provide the information, they didn't get the permit. And so some of them would do it, some of them would not. Some of them would get licensed before they ever sent in the documentation that would have allowed them to get a permit. Beginning on December the 1st, because of changes in the legislature, it says you shall issue a permit. So of interest, and we don't advertise this too much, is that the turnaround time now for military permits has gone from a prior average of 38 days for those people that pursued one to an average now of 3.7 days.
Wow.
So when we get
That's
an
amazing.
application. So we appreciate Debbie Gadd in educating us on what the legislature means by the word shall. So we're moving forward with that. We still are working on in this remote environment on customer service, and we have instituted the fact that you can now have a second line on an iPhone that can be a business line. So we are monitoring, even though the phone calls are forwarded, we're trying to pick, except during this meeting, but we're trying to pick up the calls, and then we will get the voicemails, and the turnaround time will be faster. Really working on the customer service because we know that the April exam's coming up, and we want our response time to continue to improve. How this plays out when the state of emergency is lifted with remote work, in-person work, but again we realize that the students are also under a lot of stress as well, so we're implementing that to try to help with that. You had an attachment on licensing they are having for the April exam. It's coming up for the PTs and the PTAs. There is the potential for a few rolling score days if needed. So we will be needing your services again to review the applications when they are complete and the degree has been conferred. So we feel like we are now handing you a more complete package for your review and approval. But as far as rolling test dates, we still may have some. And then after that, we'll be going into the really big time of July, which hopefully will be easier. Record retention, we have not been doing as much because the board, which is good, the board has, we're extending application deadlines. We are working with people because of the hardship imposed by the COVID pandemic. And so we've hesitated doing too much record retention with the application documents that we have because of trying to be as flexible as possible with our applicants and their particular issues. We did, however, have established now a policy. The state functional schedule says that we will keep the application for us is good for a year. But then we internally have to keep those pieces for another year before we destroy them if they're not completed. So what was happening is foreign trained applicants, we would keep their documents longer because of having to get transcripts from an overseas school or having to get your credentials evaluation. And really didn't feel like that was fair to the US trained applicants. So we have now come up with what we consider a more consistent way of managing the application documents, knowing that the applicant doesn't know that they still have to start over with many pieces of their application after a year. That's still in effect. But should they, within that second year, want to reapply, they have to reapply, but we will give them credit if their endorsement for their exam scores, their transcripts, the fact they have a social security number, and if they're foreign, we will give them credit for their TOEFL and their credentials evaluation. Everything else has to be repeated. So now we are going to be able to be much more consistent in how we manage these, both for foreign educated and educated in the United States. So really pleased that we have all come to a consensus on that. Moving on to during the renewal season.
Debbie, can I stop you for just a minute, please? David, do we need to have the board approve that as part of our functional record retention schedule? Because I think we had the board approve the other.
It doesn't hurt to just go ahead and have an official approval just for the minutes.
Yeah.
Okay, I'll make a motion that we accept the record retention policy as outlined.
Second that.
Motion's been made and seconded. Anyone else have a question for Debbie about this? Hearing no questions, are you ready for the vote? All those in favor, please let it be known by saying aye.
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 Any opposed, say no. Anyone abstaining? The motion carries. Debbie?
Okay. During the renewal season, this past renewal season, we happened to notice that someone asked a question about their continuing competence, and they had renewed their license, but they were in the renewal period, the continuing competence reporting period of 2019 to 2021. They had not completed it, but yet they were able to renew, and that the system should not have allowed them to do that. So thanks to the IT team and all of us working on it, we found that affected about 50 licensees who renewed but had not completed their continuing competence. So we emailed all of them, and we continue to monitor them, and all but one complete their requirements. They just renewed and just didn't pay attention to the fact they hadn't finished their requirements. So we monitored them and stayed in close contact with them. One person just let his license lapse and did not respond to any communications that we had, but we were glad that we caught that, and we continued to monitor it throughout the renewal process, because the system Greg built for that is quite robust, and we have a lot of confidence in the fact that it will not allow someone to renew their license if they have not completed it. So the glitch was fixed, and we were able to monitor these people. We also monitored because of COVID, and because we saw this glitch, we went back and reviewed all of the people who had revived their license in the last 6 months before the renewal season. And we made sure that they were truly aware that you still have to renew again. Even if you revived your license in July, August, September, October, November, you've got to renew it again before the end of the season. And we felt, because of everything that's going on with COVID and this one glitch, we wanted to be sure that we tracked those people down and gave them the friendly reminder, and that of the people who, they were appreciative, they renewed their license, and only 2 did not respond and did not complete it at all. And so their license lapsed. So again, we have a lot of confidence in the system, and we're able to fix it, and so all is well.
Thank you, Debbie.
Mm-hmm.
Let's move on to Prometric. Kathy?
So you've got the Prometric report from from September 2020 to December 2020. And really the information that from a board perspective that we're interested in is on the first 2 pages. Debbie and I've looked at this. I think Debbie feels like she's got some heartburn about it. And so I think, we're not used to seeing dissatisfied or very dissatisfied scores. When I look at when those ratings were noted, it had to do with the July exam, and it had to do with COVID, and it had to do with the just unprecedented times that FSBPT was going through, as well as us changing from paper to online, to whatever. And, it does say satisfaction with the jurisdiction registration process. I am now not convinced that everybody understands that the jurisdiction is your state and that FSBPT is not related to this. So I don't know if we can differentiate all of that. That said, we can always improve. And Debbie, I think, has created a plan for the licensing team. And I know she has some significant personal investment in seeing those numbers go up. So I am not worried about this. I think our staff is doing a great job, as is our board process with, now getting everything electronically to you and back. And I think it's being done efficiently and in a timely manner. that has only gotten better over the last 6-9 months. So while the numbers are lower than we're used to seeing, I think with our goal setting and ongoing improvements, I'm not worried that that's going to remain like that. I think students understandably are worried about getting their licenses, and we can't control for that factor, and completely understand the process. And so it's just that anxiety together with whether they can access us so we can explain it is key. So I don't know if anybody else got comments or different experience.
Yeah, honestly, Kathy, I mean, I think with 2020 being what it was, with our NPS, Net Promoter Scores, that we use with employees, we've seen some things that surprised us. And so I think when you look at this in context, this is actually, it's actually good. They should be commended, and the staff should be commended on this, because, with everything going on, these are actually good numbers.
Mm-hmm. Well, thank you. Thanks.
And I also think if we were able to compare across other jurisdictions, you would see that second quarter number equivalent. So it's not just North Carolina.
Yeah, and I have to believe that that's true. We don't have that, but I have to believe that that's true. So, it's good to have it, and we can compare how much improved it is going forward.
That's right. Okay, let's move on to Committee on Board Rules, number M, or letter M. And that would be back to Debbie.
Yes. Well, we are currently, again, finishing the process of going from temporary rules to permanent rules. And the timeline does allow us to continue, without any issues with the temporary rules. We're within the time frame that those are still maintained to get to the permanent rules. We are recognizing the need that with all of the changes that COVID has forced upon everybody else, that processes have changed. And so we will be convening the rules committee, because I think we need to look at what our current processes are compared to what our board will say they are. So that'll be coming soon. And we had our public hearing, and Kathy, are you going to comment on the rules request for information?
I can, if you'd like.
Mm-hmm.
So Mary Kay Hanna, APTA NC president, I think she's submitting this request, not necessarily on behalf of APTA NC, but as an interested licensee. This is kind of a follow-up request to her original request for documents related to the history of the Rules and Practice Act in North Carolina about imaging. And so I don't think she was quite ready this time, but I think a scope of practice question is going to come to the board, or either that or a request for changing rules. And so I just want to keep you apprised of it, providing you with this information for reference, now and going forward, about what the history of the rules are. I'm not sure that it has, all of the rationales, and maybe, we just don't have the records related to discussions back that far. But at least that's the history of the rules. So just, keep it on your radar that we may be having a discussion about imaging in the future. Shall we continue with schools?
Go ahead.
Okay. So you have the score reports here for the last, I included 5 years this time, mostly because the year of the report has to do, it's the graduation year. And so we're not all the way through 2021 yet. So the scores there, there's only minimum information related to 2021. So I've just given you all of it I cannot say that I feel like things have changed, significantly. The schools that we have already addressed previously that have the lower pass rates, I think they're all working on the programs that and changes that they have already described to us that they're going to work on to try to improve their scores. At least as far as the first time rate goes, their eventual ultimate pass rates are, at least equivalent with the national average. So I feel like I don't have any new information or recommendations for you about these schools, unless anybody else has something they would like to bring up. We have, I'm sorry?
I just said waiting on more data.
Yeah, waiting on more data. So the next thing is the list of PT and PTA program directors. And it became really apparent to me that we'd had significant turnover in the last quarter. And 40% of the PT program directors have changed. And so I don't know how frequently you need to have this list, but it's accessible and it's posted on our website. And, because there have been a lot of changes, and I don't know the frequency of which program directors change, but that was a big change. And so it is an ongoing effort of the board office to communicate with schools about licensing, letting them know that we provide education on regulatory topics, other ways that we might be able to connect them with FSBPT resources, et cetera. So, we like to know who's there and how we can facilitate making things smoother for them. And certainly I've gotten some anecdotal feedback that they're very happy that we went to AAP. So good news there. You've got your reference list for dates when the exams are scheduled. It doesn't always give you clear information. Well, I guess, yeah, in Debbie always sends out some updated information about the windows that they've now picked to do the exam, but at least you have the original dates that they're aiming at. I've included some communications with some of the program directors that I've had over the last quarter. There is one, I want to make sure that we close the loop on this fully. I received communication from a UNC professor about the vaccination topic. And what I think we have covered it, but what she wanted to know is also, can students do it? And I think we've answered that by saying if it's not in the PT scope, somebody needs to obtain the appropriate training and follow law to do it. And then can they do it under a PT? Well, the answer is still the same because the PT would also need to be trained, but it's not in the PT scope. So I will be responding to her after this meeting.
Okay.
And then Dean McCall, the information that he provided will be useful later when we talk about scope of practice questions. So that's that piece of information we may come back to. Ethics Commission, there are really no new bits of information. As you all know, April 15th is coming. So you want to submit your statement of economic interest, and the directions are here in the link. So just always go back to click up and you can get in there and access that. Anybody who's got their ethics training due can come back in, access it through the directions here, or just go to the Ethics Commission website. And then, yes, sir.
Can I ask you, is mine due this year or next year?
Let's take a quick look. You are due April 11th, 2022. Exactly.
Thank you.
Yeah, okay. So that's there mostly for your reference. Similarly, the response to the manual lumbar traction for PTA response from the discussion at the last board meeting, that's included here just as for reference. We did respond to the person asking the question. The physical therapy licensure compact. Debbie, do you want to talk at all about the things that you and Angela have had to consider now when we have a new compact privilege holder?
When we're trying to track in our database for public protection, and so that the public can see what type of license or privilege or temporary exemption that someone has, when these privilege holders are now applying, it's been long enough that they may be reapplying or getting renewing their privilege. So we've got to see, are they buying a new privilege? Did they let it expire? Or are they just renewing it? And our board, our participation in the compact, we require that whether they renew it or purchase a new one, they have to complete the jurisprudence exercise. What has been interesting is one of the ways to track these individuals is via their email address. And we are now, we work with Greg so that now we have a search function in our database that pulls up all of the ways they are in our admin tool, meaning were they a licensee who let it lapse? Are they currently a licensee? Are they also a privilege holder and they did it by mistake, or they got one and we don't know why? But what we have found in making sure that they have completed the jurisprudence exercise, that we now need to research all of the ways that they have ever been involved in North Carolina, because some of them, when we were tracking them, it looked like they hadn't done the jurisprudence exercise. Well, that's true for a good portion, and then we would have to track them down and say, you really, this is part of it. You acknowledged you did it, and you didn't. But there were several that we, when we researched, they had used an older email address and went into their lapsed license information and completed the jurisprudence exercise, which then didn't show up on the compact privilege. So what's really helpful now is that we can see every way they've ever been acknowledged in our database so that we can then track any issues that we're having with them. So that was an interesting learning curve, and still working on a few, but it's we now are more adept at tracking these people down.
Continued modernization and efficiency through using technology. I think that we could say that over and over and over. So thank you for that. I know Debbie and Angela worked very hard to manage that, and they provided us with a list for the investigative committee, because since it is a compliance issue, and when you have a privilege here, you have to comply with our law and rules. We did send them an advisory letter letting them know that, you attested to this, but you didn't do it. And, this time we'll let you, maybe you didn't know that, but going forward, you need to do that. So that action has been completed also. And the other thing I wanted to share with you that's particularly relevant is North Carolina's compliance with the requirements of the compact. And I've sent you the spreadsheet, and I de-identified it other than to just show you where we stand. There are 5 things that you have to do. Our weekly data sharing, 100%. IT gets a high five on that. We must report disciplinary action. And we do. The reason why it's 67% is because you have to report it within 48 hours, and I missed one by a day. And so that gave us a 67%. Going forward, we're striving for 100 on all these categories. We've reported all of our encumbrances and investigations. I think the other part of the investigations data, and the reason that that's 17% is that early on, I didn't understand how and when I needed to report the investigation, that piece of it. And what they want to see is that the person was flagged for an investigation, and then if they receive disciplinary action, they want to see that it's been reported all along, and that'll give you the 100%. So that was a learning curve on me, and going forward, I understand. The other 100%er is that we are using the FSBPT ID as an alternate unique identifier to the Social Security number. So again, minimizing the risk to our data, because they've had our Social Security numbers for years and have been able to deduplicate information as much as they can. And now they've got FSBPT ID from us. And Kim works periodically on those that need to be updated when we get a report from the commission. So, it's ongoing. I didn't fully appreciate how much, data always needs to be reviewed and cleaned and all of that. So that is our update from the PT Compact.
So let's move on to letter T, submission of reports to the state.
So in that category, you can see that we have been doing some work on that front. And I've provided a report to the state that was required on regulatory flexibility and the actions that the board has taken. You are aware of all of those. If anybody has any questions about that report that I submitted, I'm glad to answer them. We did receive a request from the Department of Commerce. It was kind of like we were selected at random, if you will, for this employment and wage survey. That's something that I don't remember having to do before, but we did that. And with David Gadd's help, figured out that that was legitimate, because when it first came in, it looked like we were being asked for people's personal information. It didn't quite look like we should provide that, but that it was a report we provided, and we did do that in a timely manner. The master crime dishonesty policy is a policy that's held by the state of North Carolina that needs to be updated every year. So we have to provide an application for that. And when we were reviewing it prior to submitting it, David Gadd asked an excellent question. And if you look at the bottom here, you have to report your history of losses that you've had. And if you may remember, I approved an invoice that was fraudulent. And so that was a loss to us, because we weren't able to recoup any of that money. And we did everything we could, even trying to find law enforcement in Florida to help us with it. In terms of renewing the policy, it was, is there something additional that we could have in this policy that might cover us from something like that going forward? So what Cindy did, and then I eventually spoke with her, is a woman who was responsible for the those policies, and her last name is Hale. I can't think of her first name right at this moment.
Not me.
No, it isn't you. It's Liz Hale. Liz Hale. We communicated with her, and the long and the short of it is they can provide some additional coverage, but apparently it is so expensive and the juice may not be worth the squeeze. And this is the state policy. So I would not recommend that we add any additional to this policy at this time. And I will say that, at least from my perspective, and I think I probably can also speak for Cindy, I don't know, that we're pretty careful, and we go back and forth now before we pick anything and make sure that, everything is since more of them are coming in electronically, we're really vetting them more thoroughly. And so hopefully we'll
Kathy, that was a really frustrating thing, though, just to let the board know that the reason the insurance company said that this claim was denied was because the payment was approved internally, meaning the check was willfully written, but the invoice was fake. So yes, the check was willfully written, but it was a scam to begin with, and that's why the claim was denied. It's, you know, it's frustrating. You have this insurance and they deny your claim for that reason, but that's what the insurance company hung their hat on, was because it was not, you know, the check was willfully signed. So that's that.
We will hope that is not going to happen again, because we are checking back and forth. We got 2 layers of security, and then if Cindy and I don't like it, we send it to Greg and get him to look at it. Hopefully that's not going to happen anymore. The IT department has submitted a written report related to their recent activities, and just really a bulleted summary for your information, and you know who's working on what, and you know what we're starting in 2021. For those of you that are not familiar with the term Black Book, our Black Book contains licensees and the license numbers they're assigned, and how they are assigned those numbers, and then how they obtained a license or revived their license. And that data is just, it's so key to maintaining accurate counts, back checking other financial data against, and we're working on that becoming an electronic resource as opposed to paper, because right now it lives at someone's house during this remote work, and that, you know, that we're just, it's again, it's modernizing. So we're working on changing that. There's a great team that's working together to look at all the angles on that and try to make that an electronic resource going forward. Again, some more licensure things to continue to remove the paper from the application process. And then, you know, I know that we have a new server that David Nall will be working to install. And that we had to wait until after renewals for that to happen. So, you know, as you can see, there's a lot going on, and there always will be. This list is probably much longer than what we've got listed here, but this is the shortest term we could provide you an update for.
Okay. Well, let's move on to scope of practice. Kathy?
I am going to ask Debbie to discuss this. She did the research for this for us, and discuss that for you.
Okay. Kim Byrne is an assistant who asked the question on January 26th. She wanted to know if a physical therapist requires an order to increase oxygen to achieve appropriate oxygen saturation for mobility. And this is a PTA. So this, first of all, the FDA, and correct me, Dr. Garcia, if I'm wrong, the FDA still considers oxygen a drug. We also checked with the Respiratory Care Board, and they also, you know, that all facilities still consider oxygen as a drug based on the current FDA classification. You would need a physician order. She is asking a good question. It ultimately is up to the physical therapist. This is an evaluative technique that if oxygen needs to be managed within the parameters and guidelines set by the physician, then the physical therapist will then determine the parameters within the physician's order regarding how it can be utilized. The physical therapist can then delegate to the physical therapist assistant the parameters, making sure that the physical therapist assistant is qualified in assessing the signs and symptoms if someone is decompensating or having issues related to oxygen and the pulse ox readings. We reached out also to Dr. Rebecca Crouch because she has had long-standing experience in cardiopulmonary and thought that her response was very well detailed and explanatory, and that yes, that you should still get a script from the physician, the nurse practitioner, or the physician's assistant related to the titration of the oxygen. But that there could be some that the therapist can work with the physician on how the prescription might be written given the parameters and the guidelines set by the physician and or the facility. And one of the ways that she stated that was that the PT may titrate oxygen liter flow to maintain an oxygen saturation of 88 to 90%. Then the physical therapist would then make sure that the physical therapist assistant had the knowledge and the training and the equipment to be able to monitor to make sure that the oxygen saturation rates that they monitored were accurately recorded, obtained, and that the equipment that they used was reliable enough to produce accurate readings. So in order to respond to her question, does the physical therapist require an order to increase oxygen to achieve appropriate oxygen saturation? The board has in the past, in 2006, stated that regarding adjusting oxygen flow and oxygen being classified as a drug, adjusting oxygen requires an evaluative component that should only be done by a physical therapist and not by a physical therapist assistant. Since a physical therapist assistant cannot adjust oxygen flow without consulting the PT assistant should not be involved with a patient receiving oxygen unless the physical therapist has determined the patient is stable and predictable. The physical therapist has a responsibility to make his or her own clinical decision based on the best interest of the patient within the parameters and guidelines set by the physician or facility. And believe that if agreeable with the board, that statement is still correct. So Kathy, do we need a motion to give us the ability to craft the response?
I think it would be helpful that the board just affirmed that the current position statement about or response to the scope of practice question is still accurate. In responding to her, I don't mind, breaking down and rewording it if they're not understanding it. But I think what is currently being told to licensees from a scope of practice point of view is accurate.
So Debbie, help me understand. It's saying that the PTA shouldn't, like if you're walking a patient and you got the monitor on them, that you can't change the oxygen, but you can walk that patient with an oximeter on and make the judgment on low or high or whatever oxygen. I'm not understanding what you were saying about that.
Depending on how the physician's order is written.
And whether that PT who is supervising the PTA has knowledge that that PTA is competent to be able to assess the patient's status, and they believe that that PTA, they've given them the ability to adjust it within whatever the parameters are. But you can't do it without your PT delegating that to you. And I think that that's really important. I think, with all of these folks that are post-COVID who are going to need rehabilitation, it's really important to recognize that, oxygen's a drug, it needs to be prescribed, and the PT needs to operate within those parameters, and then they need to check back with the physician if there's a response that isn't what you're expecting.
Okay.
I don't know, anybody else want to?
I was just going to
I
comment
agree.
that.
And
Go ahead, Garcia.
I was just going to say, because I say that's why you can't smoke in hospitals, in the hospital room anymore. We used to be able to let folks do that. So you really do have to look. You can't just base it on a number. You got to look at the patient too. And if you see the O2 sats going down to 84 and you just start turning it up, when really you should be looking at the patient to see if they're decompensating. And if they're not, you may need to try another site to check the O2 sats. Maybe they're doing all right too. So that's why you got to just be cautious when you give leverage. Sometimes I've seen folks, even nursing staff will just turn full O2, full blast when you can actually hear the O2 being administered down the hall because it's so high, when really that's not what they really needed. So had to really just monitor the patient.
That was one of the reasons that I checked with Dean McCall about what's being taught in PTA programs. And, so a PTA does have knowledge of it, but they also are educated, at least at Martin. I can speak for Martin for sure, that you need to check with the supervising physical therapist before you're doing any adjusting. And that would be an important component.
I agree with that. We usually at the hospital, if their sats are dropping like that, we get the doctor or the nurse to change it. We don't. I don't know about Crystal, but I don't change it because that's an assessment to what they have their oxygen saturation set on. Their oxygen set on in the first place, whether it's 2.5% or 3%, and that's up to the doctor to say let's increase that or let's decrease that. So I agree with that.
Yeah, I would agree. I haven't worked with patients on oxygen probably in over 10 years. But I remember when I did work up at the LTAC initially, we would always contact the respiratory therapist. They would handle taking care of those kind of things.
Yeah, I think the respiratory
we would just stop treatment and say, hey, they're desatting, they're not tolerating well, and let respiratory therapists get involved in what their next steps needed to be.
So Madam Chair, I think we should at least get the board to, confirm that they agree with the existing statement, and we can respond to the question asker with that information.
Okay. I'll entertain a motion to adopt our prior position statement on this.
So moved as directed.
Okay. Is there a second?
Second.
Crystal second. David made the motion. Are you ready for the vote? All in favor of this motion to support our prior scope of practice question on O2 for PT assistance as written. Let's take the vote. All those in favor, please let it be known by saying aye.
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 All those opposed? And anyone abstaining? The motion carries that we will stick with our original position on this. The next scope of practice question.
It's really a question for the board. I think, as Debbie and I anticipate these questions coming to the board, I've been thinking for a long time that a framework by which we consider these questions would be helpful to have in writing, so that it's kind of like when you are assessing an application, all the components that should be in there, and then you can look at the data that's being provided to you and assess whether that information is really there. In attending more of these regulatory seminars, hearing more information from other states about how scope of practice questions are looked at. I felt like we certainly utilize that permitted practice rule, education routinely taught in continuing ed and routinely performed in practice settings as our benchmark. But we need to also be looking at risk, the risk of the technique, and then the evidence base. And so Debbie and I talked about it, and within 10 minutes, Debbie had what I thought was this awesome framework to look at it. It makes it, when you put it in a picture, it makes it easier to understand how all these things relate to each other. And so it's not that we haven't done this, it's just that as we discuss these scope of practice questions going forward, I wanted to see if the board, had any reaction to this model of how we are obtaining the information about education and training. If you go to the graphic on the second page of this document, this is all the information that we're going to collect to bring to you at the meeting, to the extent that we can, and to the extent that a particular topic warrants it. We're going to look at education and training, because that's in that permitted practice rule. We're going to look at where it's routinely performed in practice. Try to do a little bit of a risk analysis on the particular technique, and then the evidence base for it. And so that's in that dark blue, the dark blue wedges. And you can see the arrows in that all of these things interrelate to each other. And then further out to, in the periphery of each one of these wedges, are where we're going to obtain this kind of information to present to you. And I thought it was genius that she called it the peer review process. Because it includes practice, education, evidence, and risk. And so we're just adding a couple of additional elements in a more robust way to take a look at some of these questions, particularly as some of these, I was going to say, more emerging technologies, or as practice continues to evolve. Some of these things are not things that I've ever worked with clinically or have any experience with. And so that way we can be very intentional in making sure that we look at each aspect of these things when we're doing scope of practice questions. So then continuing on down, we didn't include this for today because we just wanted to present this as a framework for looking at them. But where I've written steps for peer reviewing this, when Debbie crafted it, she created this sort of grid or a rubric or a way to look at it. And so, here's how we could do the ranking of practice. Is it performed in practice? Well, it's not performed in PT practice at all, or it's done routinely in all kinds of settings, so you can take a look at each one of these. And, if you take a look at it and you feel like we could refine the categories a little bit, we can do that. But these are the things that we would need to consider in order to come out at the end of a discussion with a decision, and then we can respond to a licensee or a question asker. I think the things that we are not as familiar with talking about are the evidence base. And, we don't have a rule that says that it has to be at the highest standard. The North Carolina Practice Act refers to the board establishing minimum standards. And so, I think we would want to look at the highest quality evidence that we could. And so Debbie's sort of listed a progression of the types of evidence that there might be for a particular topic or technique. And you know, certainly if everybody in that progression was in agreement on a particular topic, that provides you information. Or if there's a lot of disagreement within the body of knowledge, you know, you may want to, you know, further consider it or grant it at some limited limited level. Under regulation and risk management, so how risky is it to the public? Well, you know, the easy answer there is you look at techniques that are more invasive. So, you know, sharp debridement and dry needling and that kind of thing. Those more invasive types of things as opposed to things that are less invasive. Then what we would need to do, if anything, to allow, if it does fit within the scope of practice, would we need a rule change to allow it? And those types of evaluations need to be performed when we're answering these questions. Debbie, is there something that you would like to add that I have not addressed particularly?
No, I just think this is a process and evolution, and that as the profession progresses, the questions are getting harder, and do require some layers of consideration, because the profession is evolving.
And with a frame, I'm sorry, go ahead.
I was going to say, listening to your presentation on this and seeing that report, it looks like it's some original work that you have done, and you should submit it for publication.
Yeah.
I think it's a fantastic document, you know, definitely.
Yeah, Debbie did a great job. Thank
Yeah, very good.
for saying that.
No, you did.
I agree.
Team effort.
It's very well done, Debbie, and also to be able to have a written reference, because when I think back over the years that I served and the different times we've had questions, you know, and we go through the same process and the same questions every time, but to have this as a reference is really nicely done. And I love your peer term and the diagram and everything. So and I agree. Share it with the other states.
Yeah. Kudos, Debbie.
Other boards, other disciplines.
Right.
So Debbie, what is your commission for this for other states?
Copyright it, Debbie.
One of the references, I'll also add, one of the references that I think was particularly inspirational to Debbie was this document called Changes in Healthcare Professions, Scope of Practice, sort of how a legislator looks at scope of practice, or it's a guide for how a legislator could look at scope of practice. And you know, these are the questions that maybe they would be asking, and we should be able to answer those questions. So, you know, I thought this was all around great job, and it'll give us something to use, and we can go through it with each question that we have. Today's was a little easier because we already had some kind of a standard to go by. But in light of, you know, how much we've identified that particularly certain populations are going to be at high risk these days, we needed to look at it again.
You know, again, if we're looking at a question potentially being posed about imaging, you know, that's getting pretty progressive. So
yes,
we need to peel back the layers of the onion and really be sure we've done our research, and then are we ready to do that? Or are North Carolina, you know, PTs and PTAs ready to do that? What do the rest of the states do? And can we manage it? You know, as a board, can we assure the safety for the public? So.
Well, and I appreciate the standardization that these questions will lead to decision-making by our board, whether it's the people that are sitting here today or people sitting here 10 years from now, so that you're not the one having to prompt it every time, but there's a framework for consideration that can be standardized across all questions, all scope of practice questions.
I love it. So I think from here, what I would say, I'm hearing that the board likes this framework. And so for the next meeting, I think Debbie and I will have more of a step-by-step how we're going to look at each question, and we'll come back with something that's an easier step-by-step kind of guide. This was just the framework. And
yeah, I think it's great.
For the next time.
All right.
Good job.
Moving on to dry needling competencies review, HumPro.
HumRo. I just wanted to let you know that there was that study was actually really important during the lawsuit, and there has been an updated look at the data, and so I'm just providing that as information for you as it relates to dry needling, and it's a reference that we can use going forward should we need to, if we have additional scope of practice questions about it.
Okay.
And that just came out, and I just became aware of it.
The next item on the agenda is we need to select an FSBPT alternate delegate for 2021. Before we do that, I'd like for Crystal to share her experiences as the delegate last year and what that was like remotely.
I think Pearl was the
She was
delegate, who was
Pearl.
the alternate.
Oh, Pearl. Pearl.
Okay, I was
I
muted.
think she was on mute.
It was really good. Everything was set in motion as if you were in person. They had everything set out. I thought that the session that they had where we went in and they discussed with us what we needed to do once they had the actual delegate meeting, I thought that was awesome, because once you got to the delegate meeting, we were able to understand what it was we needed to do and how we needed to do it.
Mm-hmm. Yeah, the pre-assembly training sessions were very useful. It was very informative. So on the day of the delegate assembly, everything just moved like clockwork. There were really no issues had.
I was asked to be a teller at that meeting, and before I thought about it, I said, sure, I'll be a teller. I had no idea I was going to need 2 computers, my phone. I was going to have to, be, managing multiple inputs. And I'll tell you, they had a script for everything, and you knew exactly what you were supposed to do, and you did it. It was the right time. So it was very well run. So I would encourage anybody who's interested in that process to throw your name in the ring if you're interested.
So I'll be the chief delegate. Is there someone who'd like to be the alternate delegate?
I don't mind being the alternate delegate. The problem is I don't know if I will be on the board then. I doubt if I'll be on the board then, but.
Well, it's this year, Pearl. Aren't you still on the board this year?
Well, that's a question for another time, but if I am, then I will, but somebody else probably need to. Yes. I can't say yes.
Okay. Would someone else be willing to serve as the alternate delegate?
What was the date, Teresa?
The dates are October 22nd and 23rd.
Sadly, that's New Orleans and Halloween.
Oh.
How long did it take last year, Pearl? Wasn't it just a couple hours in the afternoon? It may have been an hour training and then a couple hours later. Was that right, Crystal?
Yeah, it was like an hour that morning and like 2 hours that afternoon.
That's
maybe
what I
an hour and a half. I was actually out of town and did it in my camper.
That's right. I remember that.
Perfect.
Teresa, I mean, if it's only a couple of hours, I mean, I can certainly do that.
And you would only be called upon should the delegate not be able to fulfill their duties.
I'm also available if you need.
Okay, well, I hear David offering. I hear Leslie offering. Either of you have a strong desire to be the alternate? Eeny, meeny, miny, mo.
Coin toss.
Leslie, how about you do it? Just because I know David has other responsibilities with finance, and the ED performance review. So is that okay with you, David? Okay. And he has New Orleans and Halloween, so you know. So Leslie Kessler will be our alternate delegate.
Thank you.
Thank you, Leslie.
We will let them know that you are the alternate.
Okay, Clear, Kathy, you want to talk about Clear webinar series?
Well, just to let everybody know that, you know, Clear is another organization that we participate with. And since the FSBPT has gone to more remote type learning activities, Clear's really stepped it up a lot. And most recently, there were several people that wanted to attend a board, like board member type of training, and they may want to speak to whether they enjoyed that or thought that was well done or good. David Edwards went.
Yeah, it was good. And first it's like, what does clear mean? And I put up my little reminder, my little cheat sheet, that it's the Council on Licensure, Enforcement, and Regulation. What I found was interesting about it, it's not just PT or one thing or the other, it's all kinds of different licensed professions. And it's not just, you know, I think it's based out of Canada, if I'm not mistaken, but it involves different countries and many different perspectives. I think there's a lot of learning and, you know, and cross education that can occur with these. And I thank the board for sponsoring that.
Mm-hmm. So it's just available. They've got a lot of topics. The question that I had for board members are, do you all receive individual emails about that? Because if you don't, I'll forward them, and then you can, you know, if you see a topic that's of interest, you know, just let us know. But you know, it's another avenue about which to understand your role as a regulator. And when I listened to the very first webinar of the webinar series on that Dale Atkinson provided, the topic of getting your head out of your clinical role and your role as, you know, in your day-to-day work and putting on your regulator role was really important. And that's where these additional trainings are helpful in, you know, helping you kind of categorize the way that you think about your role as a regulator. So that's the reason I continue to put it on here.
I think I signed up for like all 4 or 5, so I've already got them scheduled.
Yeah. Clear is also the organization that we do the investigator training with. So, you know, they've got a wide variety of things.
I think it's helpful since they didn't have that training that would have been in June to have this, because even though we're getting those monthly, I didn't have that basic training in the beginning.
Yeah.
So I think it's helpful to have that.
Yeah. Yeah. I think you and Rosa got a short straw, but if they reinstate it, if we get there next year, hopefully the 2 of you can go, because I think that in-person one's really good. But in the meanwhile, there's some other options. Last couple of things that I have are just a few articles, emails, responses that I've received, and so you can take a look at topics that maybe you haven't been aware of before. And then a reminder about the upcoming board meetings. I had to leave briefly while you all were talking about the next meeting. And at this point, you know, do you want to discuss whether this meeting changes from our remote, or are we going to do the next one remote and then anticipate September would be in person, and then we can see if we can't get the conference room downstairs?
Speaking for myself, I love Zoom, but I've had enough. If it falls within the governor's guidelines, there's a level of comfort with everybody else, I would prefer to meet in person.
I would second that, David. I mean, and I think a lot of that, like say, depending on governor's guidelines, has everybody had their 2 doses of the vaccine?
I've got my second one coming Friday, so I'll have
Yeah,
all mine by
you
June.
know, and then comfort level of the rest of the board members.
And the board staff, because the board staff has to be there running the background of the meeting.
Right.
I would certainly support in-person meeting on June 9th. Can I have let me have a show of hands of who would like to meet in person June 9th? Not Leslie, okay.
You're on mute, Leslie.
Either way, I mean, we still accomplish the work, and then not having that extra day of travel is not a bad thing with my workload, but I can make it work either way.
Okay. Well, I think the majority of board members are supportive of an in-person meeting June 9th, pending any changes to the governor's directive.
So we'll take a look at those and we, monitor that. So put it on your calendar.
Okay.
And we need to make sure that works from
Would you offer a Zoom option in case someone has difficulty getting there?
Yeah, there was something, the one thing I feel like I have to look at is the one law that came out last year that talked about requirement to stream or a meeting or have a live way that the public can participate. There was something in that about board members' attendance, and I can't remember exactly what that said. So I would like to be given the option to take a look at some things and then get back to you before we make a lot of plans.
I think, Kathy, historically, pre-COVID, we'd have to have call-ins periodically and so forth. And
yes,
so not
we
sure how.
just didn't have that other law then, and that's the only part I just don't remember.
Certainly, absolutely.
So are we talking June 9th or September 22nd?
Well,
Would it be
June 9.
June 9.
I'll get back to you with a summary, and we can do that on email, I think.
Okay. So I've got 10 of 12. Am I right in saying the only thing we have left is closed session?
Let me just validate that, but I believe that you are correct.
And if that is true, do you want to just plow on through and be done? Or do you want to take a lunch break and come back?
We need to wait until 1 o'clock because that's what's been advertised to people that are participating.
Okay.
Yeah. I mean, David, would you disagree with that, David Gadd?
You talking about just for the closed session?
Yeah.
So we've got folks who are attending who are witnesses and that sort of thing. So I'm not sure that we can modify them, can we?
Okay. All righty.
Yeah. But what we could do maybe is have lunch 12:30, come back and do the non-people participatory things.
That would be fine.
Okay, so why don't we do that?
Since those are in closed session, we don't necessarily have to worry about the YouTube portion of that. But we probably do need to stick with the timelines that we've given the other participants.
Yes. All right, so lunch will be 12:30. David, do we need to adjourn from this portion of the meeting before lunch, since we will come back into closed session?
No, we'll just recess.
Okay.
So we'll recess and come back to this Zoom call, and then there will be a motion to go into closed session.
Right.
And then we'll come out of this, go into closed. Okay. Everybody clear on that?
So come back at 12:30.
Good.
Okay.
You have a 40-minute lunch. Bye.
Thank you.